Today, we're diving deep into one of the most powerful and honestly sacred principles in Philippine law, Rule 1002, the Writ of Habeas Corpus. Now, don't let the Latin name intimidate you. Think of this as the ultimate emergency lever for liberty, the law's most powerful check against anyone who unlawfully holds a person. Let's break down exactly how this great writ works from start to finish.
Welcome to LexAI. We're your AI-powered guide to making sense of the law. Here, we take complex legal rules and, using a bit of AI magic and a lot of legal analysis, we turn them into something clear, visual, and most importantly, understandable. So, how does this all work in the real world? Well, we're going to follow the entire journey, the whole life cycle of a habeas corpus petition. We'll start with the basics of the writ, go through filing, see it in action, cover the hearing and judgment, and then wrap it all up with the key doctrines you need to know. It's the complete playbook. Okay, first things first. What is the Writ of Liberty? Before we get into the nitty-gritty of filing and hearings, we have to understand what it's for and, just as importantly, how far its protective power really goes. And right away in Section 1, we hit a hugely important point that a lot of people miss. You hear habeas corpus and you immediately think of someone illegally locked up in a secret jail, right? And yes, it covers that. But look at that second part. It's also for when the rightful custody of a person is withheld. This opens up a whole other world of applications, particularly in family law. And this isn't just some academic trivia. This is a classic bar exam question. So, can you use habeas corpus to get your child back from someone who's refusing to return them? The answer is a big unequivocal yes. Section 1 makes it crystal clear that this powerful remedy isn't just for prisoners, it's for parents too. Okay, so you've established a valid reason to file. What's the next step? Let's get practical and move into the filing and issuance process. We're going to cover who you go to, what your paperwork needs to say, and what the court's job is at this early stage. Now, where you file matters a lot. Think of it this way. A writ from the Supreme Court is like a master key. It can unlock a door anywhere in the Philippines. But a writ from an RTC, that key only works inside its own judicial district. Choosing the right court is a critical first step. The petition itself isn't meant to be complicated, but you have to get the details right. Section 3 basically gives you a 4-point checklist. It's got to be signed and verified. You have to say who is being detained and who is doing the detaining. You need to name the place where they're being held, and if you can get your hands on it, you attach a copy of the commitment order. Simple, but crucial. Here we see the two sides of the same coin. On one side, Section 4 lays down the red lines. You absolutely cannot use habeas corpus as a sneaky substitute for an appeal you forgot to file. If a person is detained under a valid judgment from a court that had jurisdiction, habeas corpus is off the table. But on the other side, you have Section 5, which is just as powerful. If the petition looks correct on its face, the court must grant the writ. It's not a choice, it's a ministerial duty. And this leads us to a classic pitfall that has trapped countless law students. So let's say a person is convicted. They miss the deadline to appeal. Can their lawyer then file for habeas corpus to argue that the trial had errors? Is that going to work? No way. Section 4 is an absolute bar. Habeas corpus is about the fundamental legality of the confinement, not about relitigating a trial. All right, the petition was good, and the court has granted the writ. Now the action really starts. Let's look at what happens next, how this incredibly powerful legal document is actually served and executed, and why the rules are designed to prevent anyone from dodging it. You can see right away that these rules are built for the real world. The writ is aimed squarely at the person who has actual custody. Don't know the exact legal name of the person being detained? No problem. An adequate description works. And here's the best part, the real kicker in Section 9. A simple defect in the form, like a typo, is not an excuse for disobeying the writ. The law cares about substance, about liberty, not about technicalities. Okay, the writ has been served. Now the ball's in the respondent's court. They've been commanded by a judge to respond. So let's dive into this next phase. What exactly is their duty, and what is the court looking for during the hearing? The respondent's official written answer is called the return. This is where they have to formally explain under oath why they are holding the person. But a piece of paper is not enough. The name of the writ, habeas corpus, literally means you shall have the body. And Section 8 is serious about this. You must physically produce the person in court. The only, and I mean only, exception is if they are so gravely ill they can't be moved. And the law demands complete transparency in that return. There's no room to be vague.
As you can see here in the breakdown from Section 10, the respondent has to be upfront. Do you have the person in custody? Yes or no? What's your authority and the exact cause? If you transfer them, you have to say to whom, when, and why. The court leaves no place to hide. Now this is a brilliant and critical distinction. Not all returns are created equal in the eyes of the law. Under Section 13, if the government is holding someone under a warrant, their return is considered prima facie evidence. But if a private person is holding someone, say in a custody dispute, their return is just their side of the story. It's just a plea. The burden is entirely on them to prove they have the right to custody. So we've reached the climax of the process. The petition has been filed, the writ issued, the return made, and the hearing is done. This is the moment of truth. Let's look at the court's final ruling and the very serious consequences for anyone who dares to ignore the writ of liberty. After hearing everything, the judge really has a few main options. If the detention is unlawful, the order is simple: discharge. The person is set free immediately. If the detention is lawful, they're recommitted to custody. The court can also grant bail for non-capital offenses. But, and this is a key limitation to remember, a habeas court cannot grant bail if the person is charged with capital offense. So what happens if someone defies the writ? The rules put a price on disobedience. Now, I know what you're thinking. 1,000 pesos doesn't sound like a lot of money today, but you have to see it for what it is: a clear written penalty that says there are direct consequences. It's the principle that defiance of the court's highest writ will not go unpunished. And what specific actions trigger this penalty? The rules lay out the big ones: refusing to issue the writ in the first place or refusing to obey it, unlawfully rearresting someone for the same reason after they've been freed by the court, or playing games by illegally transferring a detainee just to dodge the writ. All of these actions have teeth and can lead to fines and even contempt of court. Okay, we have covered a ton of ground, walking through the entire process. Now, it's time to distill all of that information down to the absolute must-know, high-yield takeaways. These are the core principles you need to have locked in. So let's run through them. Number 1, habeas corpus is not a backdoor for a lost appeal, ever. 2, it is absolutely a tool for child custody disputes. 3, the whole process is built for speed. 4, when it's private custody, the burden of proof is on the custodian. And 5, remember, a habeas court cannot grant bail for a capital offense. Get those 5 down, and you've got the core of Rule 102. And that really brings us to the fundamental truth of it all. In summary, this topic teaches us that the writ of habeas corpus is the ultimate legal instrument to swiftly challenge and correct unlawful deprivations of liberty. It is, and always will be, the great and final safeguard of our freedom.